Welcome to IIDRC podcast series. For decades, litigation has been the calling for disputes, but now, as cross-border disputes and fast-growing economies are there, arbitration has been the answer. I am here joined with Ms. Thara Gopalan, the Vice President of International Center for Dispute Resolution. Welcome, Thara.
Thank you.
Before we start, I would like to acknowledge and thank our knowledge partner, MMK Law Chambers, which is led by Dr. Misha Kumar, FCIARB. Suthara, corporations, sophisticated corporations, are nowadays moving towards arbitration and they have just left litigation.
I think court systems around the world are overwhelmed. There is a great number of cases that parties have filed, and the court systems seem to be overburdened and not able to get through to these solutions quickly. The other complexity is, of course, cross-border trade has grown extremely significantly over the last 20 to 30 years. In that situation, one party is always going to be slightly nervous about going to the home jurisdiction courts of your counterparty. Will you get a fair hearing? What happens if your counterparty is a government or a state-owned enterprise, or in India, a PSU? Is a national court going to be fair to you as the outsider in that respect? So arbitration has therefore become a little bit more of an accepted mode of dispute resolution. The New York Convention just means that you have enforceability across the world with much greater ease than you would be able to enforce a foreign court judgment, for example. The difficulty is, of course, that as arbitration has developed over the last 100 years, in the case of the AAA, arbitration has, in some institutions or in some jurisdictions, become as complex as litigation and takes sometimes as long as litigation, if not longer. So the trick, and to continue to have commercial actors be in love with arbitration, and for us all to therefore have jobs, the arbitration has to continue to be this efficient system that remains enforceable around the world. And that's where your challenge and my challenge lie.
As a litigator as well, I see that there is a lot of burdening and there's a lot of the corporations suffer a lot when they go for litigations. However, we have seen a reverse change in India where PSUs have gone back. They've just issued a circular stating that any matters which is more than 10 crores will be litigated and matters below 10 crores are going to be in arbitration. But again, there is a lot of suffering that is there in litigation. And as you rightly pointed out, that the arbitration is in some jurisdictions becoming more like litigation. So why is arbitration becoming more like litigation in that sense? And what can we do to stop it?
I think two broad things come to my mind, right? Arbitration has to remember that its purpose is not process. Its purpose is to resolve the substantive dispute between two particular parties. And where arbitration sometimes has a tendency to become litigation is when adjudicators or when institutions become overly concerned and constrained by process. That sometimes appears in two forms. One, arbitrators who end up getting bogged down in process. Whether you're stuck with technical objections to the way pleadings have been drafted, or getting bogged down in document production requests, or a million interlocutory applications. Does that really need to happen? Should the arbitrators be engaging in every procedural skirmish? Or should we understand that the real fight is at the substance of the dispute? And these are all minor battles that we should not lose sight of ahead of the bigger war. The second thing is, of course, it's becoming an increasingly competitive landscape in arbitration. institutions are under pressure to innovate. And what is the easiest form of innovation? Let me whip out my rules and see how I might tack on a few more things to these. That's something that I fundamentally disagree with. There have been key innovations in arbitration. For example, the AAA was the first to pioneer emergency arbitration, as well as expedited procedures in arbitration. And those are things that have found their way into most arbitration procedures. But beyond that, if the sort of process that you're looking at is a more customized process, if it's not too bridge afar from the way a major arbitration is conducted, do you really need that additional rule? Do we need to turn this into rules of court, where if we don't find some hook, we can't find procedure? That fundamentally, in my view, forgets what arbitration was meant to be. It's meant to be a process that's customizable for the parties in every case they're in. It's not meant to be a one-size solution that fits all the needs of dispute resolution around the world. And I think that's where institutions need to be a little bit more mindful. We had our last rule revision in 2021. Since then, a lot of the things that we've put in, other institutions have put in, and that's par for course. That happens everywhere. But we've been quite circumspect in not adding and overcomplicating the rules, trusting that the arbitrators and the parties will find a process that works for them.
Yeah.
The rules at the end of the day are meant to set a little bit of guardrails, right? What are the basic building blocks, the basic elements that ensure natural justice, that ensure procedural fairness, that ensure due process, essentially? Beyond that, do we really need to get involved in the minutiae? Or can we not just trust the parties and the arbitrators to be able to come together with a fair process? If they can't, and that's a big if, and I will tell you as an institution that rarely happens. If they can't, there are again safeguards to be able to deal with those situations. But I'm not sure that we need to police the process of arbitration to as great a degree as many people have taken it to these days. Whether that's through running to the courts at every procedural skirmish, or whether that's through bullying the arbitrators and the institutions, that ultimately tacks on a ton of time to the resolution of that ultimate dispute, which is exactly what the parties are complaining about. So it's a little bit of a cyclical problem where behavior continues to perpetuate some of the problems.
The parties, the corporations, businesses, they also tend to overstretch these proceedings when they somehow feel that they might lose. So what would be your advice to a GC or to a CEO? Choose arbitration as a strategy and how to actually deal with that arbitration.
So I always think of arbitration or litigation for that matter as one tool that you have in your toolbox. My own background is as a shareholder disputes lawyer. So for me, getting to that arbitration or getting to that litigation is the last step in a very long leverage campaign. But ultimately, especially if you're looking at a purely commercial dispute, right? Something in relation to damages, where your remedy is ultimately damages. It's a dispute over money. Is that not something that we can come to the table to be able to discuss in a civilized fashion? I used to tell my clients this: whatever you save or you think you save in terms of your settlement costs, it's just money you would have paid me as your lawyer, and to go through a rather painful process. So sometimes I encourage parties now at the outset of a case. We have an integrated dispute resolution process. If the parties agree to arbitrate under ICDR rules, they actually agree to mediate under ICDR rules unless you opt out. So there's still that element of a consensual process. But if it's ultimately a dispute over money, is that not something that you might be able to talk about to come to a resolution? I mean, coming together to actually find a solution. Sometimes that's a longer term solution. Sometimes that's an immediate monetary solution. But where we live, where we work, it's a culture of relationships.
Yes.
It's a culture that values continuity of those relationships. Sometimes that final lever of arbitration and litigation, you need it as a stick to get the party to the table. But your real solution is a commercial solution.
Yes.
And in many cases, a legal solution, a black and white solution, may not actually be your commercial solution. And it may not solve all of your disputes, especially as disputes get more complicated. We're fighting in multiple forums, in multiple jurisdictions, over multiple things in relation to one problem. That becomes overly complicated. But the heads of these companies coming together sensibly, with an open mind, with someone who's experienced, who has sort of seen these things play out, to be able to come to a mediated resolution. I think that has a lot of potential that is especially untapped in this market. And I think in certain other markets, that culture is a little bit more developed. I'd really like to see that integration of multiple tools in the toolbox being used more effectively all over the world, really.
I can make a parallel with the litigation process is that when you litigate, there is ego battle as well. They feel that they are being dragged, they are being harassed, and that brings in a lot of friction between the parties. However, as you rightly said, that arbitration, that there are doors open for the parties to actually resolve.
The other facet of it is litigation is public. Once you've taken a position, you've drawn a line in the sand, it's harder to walk back that position. Someone will dig up your previous statement or your previous filing and use it to contradict you, and it's just unnecessary. But the benefit of the arbitration is, of course, that confidentiality of that process. You disclose in the public domain what you need to disclose if you're a listed company, for example. For the rest of us, it's an entirely private process. That takes out, I feel, some of the tension. So in an ICDR process, one of my favorite things is something called an administrative conference. We do this right at the start of a case, before the arbitrators are even appointed. It's just the parties and the case administrator in the room. And usually in my cases, these are all done via Zoom because it doesn't make sense to convene everyone physically. They're all in different countries. So the first thing that I do is, gentlemen, you can drop the ties if you want to. You don't have to put on a tie. You don't have to put on a jacket. It's just me. Let's just have a chat. I make it a point. I call everyone by the first name. These guys or ladies who might be 60, 70, sometimes 80. I call them Rodney. I call them James. They call me Thara. Right? It eases the tension a little bit. You don't treat it like an adversarial process in that instance. You try and bring the parties together so that they feel there is some scope for a collaborative dispute resolution. I think that's also one of the functions of the institutions in these processes. Can we take the tension down a notch so that parties don't get unnecessarily embroiled in procedural skirmishes? They know they have a battle. They know they're going to get there. But most of the time, they're represented by sophisticated counsel. Can we just sort of get to that process without inflicting too much damage on each other? And maybe the parties will be able to continue working together after that. You know what? 51% of all cases settle without the need to go to an evidentiary hearing, without getting to a final award. I really do think you can encourage them to work out their differences. I believe in that, the power of communication to create that environment.
So we've talked much about institutional arbitration. And when we talk about institutional arbitration, naturally ad hoc arbitration is also talked about.
Yes.
And when we talk about ad hoc arbitration, then we start talking about the clause. That's the root cause of giving your disputes to either ad hoc or having a mediation or arbitration. And I know that ICDR has an I think a
Clause builder.
clause builder.
Yes,
Yeah,
that's right. A couple of practical examples that I've seen. Okay. Contracts with two dispute resolution clauses that conflict. I have seen quite recently an ad hoc clause with a sole arbitrator in the same contract, an institutional clause with three arbitrators, different seats of arbitration. So some examples of perhaps carelessness or just getting through it too quickly. But when I looked at it, it seemed like those were standard terms of contract. And that worried me. I wondered how many of those had gone out. Right. So that's one thing, putting some thought into it. I think the other thing is also think about the process for that particular dispute. Every contract is a little bit different unless, you're one of these mega companies and you have like 1 million vendor contracts, right? But for the most part, for the larger scale disputes, the contracts tend to be different. So what is the best process that would work for resolving that particular relationship, for resolving the issues that you foresee will arise in that relationship? That's one thing, but that's maybe a certain higher level order. At the very basics, the things that I think people need to be very clear about, choose your rules carefully. I have seen contracts that say we would like the AAA to administer in rules of institution X.
That's bizarre.
Is bizarre. That doesn't quite work in the same way that institution X cannot administer a AAA or an ICDR case. The second thing is choose your seat of arbitration well. It could be a strategic choice. Do you think you want a more interventionist court? Or do you want a court that is more likely to support the arbitral process? What is the thinking behind that choice? The third thing is understand the systems of law that are in place. You've got your governing law of your contract. You might have your law of where the business is being done. You might have the law of the seat of arbitration. Which system of law applies and why? And therefore, what is within scope and what is out of scope? Those are things to be very careful about. And my favorite example is this. One of the major cases that I argued as counsel in Singapore was this case BNA and BNB. And the issue in that case is how express does an express choice of law have to be? So if you have a contract, the contract says this contract shall be governed by the laws of Shanghai. Does your dispute resolution clause end up being covered by that clause? Under Singapore law, the answer is no. It does not automatically. It comes in as a possible implied choice of law that can then be displaced under the Sole America framework, right? But to a commercial actor, if I specify in my contract, this contract will be governed by a system of law, that commercial actor expects all pages of the contract have the same law. So those are things that we need to be a little bit careful about. In India, of course, the example that comes up most regularly in my previous life was the interaction between arbitration and the NCLT. Because these are very multifaceted disputes, right? And you might have some things that can go to an LTLT. You might have some things that go to arbitration. I know there's a present conflict about all of this in the Anupam case that I cannot quite comment on because my previous firm is involved. These are interesting legal questions that you do need to think about. And they happen in certain contexts, not in every context, admittedly. But spending more than 2 seconds looking at it is worth the time.
Worth it, yeah.
Because you could end up in a very painful and expensive process later. And the other thing is, use the tools that the institutions have developed, right?
Yeah.
Institutions like yours and mine have model clauses for a reason.
Yeah.
We know it works. We tell you how to be able to develop the model clause for your specific scenarios. We understand within our rules certain things, if you don't put in, that we can fix it.
Yes.
But there are certain things we cannot fix.
Yeah.
So use the tools. Like you mentioned Clause Builder.
Yeah.
Clause Builder AI is a publicly available tool that is free to use. It's absolutely free. Anyone with an internet connection can use this tool. Take advantage of that. We built it so it can be used, right? Use it to interrogate your clause. Use it to be able to understand what else you ought to be putting in there. That comes from clean data that we have from, 9.5 million cases over the last century. So that's data that you as a party should be taking advantage of. Using the institutions as a resource is something that the parties have to take advantage of. I want to see more of that.
One word advice from you that can be given to the businesses, that what things that they can take care of when they are looking at their dispute clause.
Objective.
Okay.
Are you looking to preserve a business relationship, or are you looking for a solution that is enforceable?
Okay.
Or both?
All right.
Seat of arbitration.
Mm-hmm.
You got to be very careful about that, because that determines how much interference there is in your process. 3, which institutional rules and why are you choosing those rules? Copying and pasting from a random contract rarely works. 4, interrogate the institution. Ask for data. Ask for statistics. What are their resolution times? What are their costs? How much is transparent? 5, pick your arbitrator well. You don't necessarily have to write it in your clause, but look for arbitrators that are specialists in that particular field of your dispute. If you have a technology-related dispute, a construction-related dispute, an energy-related dispute, or a life sciences-related dispute, these are all specialist areas that most commercial lawyers won't begin to understand how business is done in those areas. You need a specialist adjudicator. To what extent have you gone to find that adjudicator? And if you've not, to what extent can the institution help you? Those are things that I would bear in mind.
So let me move on to something more transformative in our sector, AI and other digital technology that is being used to resolve these issues. How do you see that technology playing out for the field of arbitration, mediation, and specifically dispute resolution?
I think if someone hasn't started using it already, they're about to get left behind. Every major institution, every major law firm, every major corporate has put technology into their process in some shape or form. In the early 2000s, we introduced online case management tools. We've kept reinventing the wheel of that case management platform. We're now currently, I think, at version 3.0. And very soon, within 2 years, we're going to launch version 4.0, which is essentially an AI native case management platform that has all of these inbuilt AI tools into the platform from the get-go. It then becomes up to the parties to decide how much or how little of it they want as part of the process. So that's one thing. The second thing is that artificial intelligence is going to transform dispute resolution, whether you like it or not. I think the Supreme Court last week already issued a statement about the use of generative AI by counsel in submissions. Frankly, that's slightly unfortunate that there isn't that verification that was done in those particular cases. But I think for the most part, counsel are fairly sophisticated. Counsel understand that while the AI can give you potentially a first cut, that you do need to verify, and that's pursuant to our ethical obligations as lawyers as well. But quite frankly, beyond that, a lot of the other problems that we used to have of hallucinations and all of that, those are problems that have been resolved. You just end up using a closed system, not a free tool. You limit the access to information that the tool has so that it really does not invent things. It goes back to information that is stored within a particular system. The third thing is that I really do think that arbitration by an AI will eventually become a thing. The fact of the matter is that you've got different scales of arbitration. Not every arbitration is $1 billion arbitration. You've got arbitrations that are $10,000, $20,000. And do those kinds of disputes really need a full-on hearing with a full-on human arbitrator that makes the cost of resolution of that process simply not worth going after that money? Yet, parties in those processes still deserve an ability to resolve their disputes. One of the tools that we've built is the AI arbitrator.
I was going to mention that.
That is revolutionary. It is built on a whole system of different agents that do different things. But that still is not a fully AI arbitration. So maybe let me explain why. The way that it works at present is claimant files a case on the AI native platform I mentioned earlier. The respondent then has to consent to the use of this AI arbitrator. Right now, the AI arbitrator is only deployed on two-party, documents-only, US domestic construction cases. A lot of different qualifying criteria.
But it's still experimental.
To some extent, it's actually been trained on a bunch of data already. So it's been trained on 1,500 AAA construction awards. That's why we deployed it into the construction space. And that's also because we see about 6,000 construction disputes every year. In comparison with our total caseload, it's a small percentage. Yet, this is an industry that will crack under the pressure if there isn't a fast dispute resolution mechanism. Because we all know it flows down from employer to your subcontractors. And those guys need to get paid for the wheels of commerce to keep turning. So I mentioned the respondent then has to consent. The AI arbitrator will then ask the parties to summarize to put in all their papers, what is their position, various authority, all of that. The AI arbitrator will then ask you to confirm that the summary it has produced is accurate. Now you tell me, how many judges do that? How many judges will actually ask you, have I understood your case correctly? This is what your case is. Nobody does that.
So it gives you a chance as well
to correct. At that point, the AI arbitrator will draft an award. And a human arbitrator is then put into the loop. The human arbitrator reviews the award, makes whatever corrections, amendments that needs to be made, and ultimately the award is signed off by a human arbitrator. And so that award can then be enforced in any court around the world and all of that. I think this technology has vast potential. One, not just in terms of arbitration, but if you're thinking about neutral evaluation, for example, this could maybe give you an indication of where your dispute is at. And that is something that you may then want to take into a mediation to be able to resolve the dispute. We are training the AI arbitrator on other sets to be able to expand out that offering to other industries. I do want to see this AI arbitrator being deployed
Yeah.
in a much more extensive way. We've already had our first case.
Yeah.
And this has only been around for 3 months at the moment to see how this plays out. And I'm sure with the one case, more will eventually come.
Yeah. With the AI arbitrator, it is going to facilitate, like, sounds so promising. But I need to ask you that question that is asked by a lot of people. There are people who are going to say that, is it going to take arbitrators' job? Is it going to affect the results of the parties?
Two answers to that. One, as it's currently deployed, it's really intended for very small cases. Those are probably the cases that you don't want to get as an arbitrator anyway. Because the reality is you're not going to make very much money off of those cases. And those are cases that probably, I think, can more or less be dealt with by the technology. They're less complicated. They're documents only. Doesn't really need too much human intervention. Is this going to replace arbitrators entirely? The answer is going to be no. In complex cases, we know it turns on more than just the documents. It turns on interpretation, it turns on witnesses. There are complex geopolitics and public policy concerns, reasoning, and all of that. And I'm sure that AI is going to learn to be able to deal with all of that eventually. But the great thing about the human condition is that we're very creative. We will run novel arguments every time. And that's the fun of our job as counsel, really. I don't think there will come a day in my lifetime when the AI will replace us completely. I think it will continue to be a collaborative process.
People are using these tools to actually, enhance their practice, to save more time. But then the problem again there, that they are trying to use it as a cut, copy, paste tool. So I think that is something that we need to change.
You're absolutely right. I think if you're sort of someone who has been copying precedents and that's the entirety of your practice, you would probably be replaced. But the honest truth of it is that most lawyers don't have that practice. I like to believe that most lawyers appreciate the craft of practice, appreciate that what's special about them is that they bring their experience, their understanding, their ability to see the angles, to be able to craft a case for their clients. And what's special about an adjudicator is your ability to see through the angles to the crux of the issue, to be able to arrive at what we hope is a just outcome for the parties. So,
okay, I'll just stop you there and ask you a question. Do you think that the AI is going to cross that threshold where the genuinity that we have, the arbitrators and the counsels have, is it possible that AI might learn it and it might cross that stage as well, that threshold as well?
If it's a pattern, if we can sort of teach the AI that as a pattern to be able to then recognize behavior, yes. How would we do that? I have no clue. So I query whether something would be able to do that. I think it's not outside the realm of possibility.
Yes.
But my question would be, how would we go about training the AI to do that? It might be possible. Maybe it's got certain body language cues that it picks up, especially if you've got, video recorded testimony, for example, or voice recorded testimony, for example. But I think it would be incredibly difficult.
Yes.
Because the other thing, doing cross-border work, the same pattern of behavior can be interpreted very differently by two different people.
Yes.
How would you interpret silence, in different contexts, across different cultures, depending on what hat you're wearing, whether you're a counsel, you're a client, you're a mediator, you're an arbitrator, you're an institution? you're from Japan, Korea, the United States, South America, India, China, wherever you're from, how would you interpret it? How would you deal with it? Right? We all know the answer will be different.
Different.
How is the AI going to do it?
So that brings me to the question that with the advancement in digital technology and AI in arbitration, how is it is going to change how arbitration and mediations are going to happen?
I think parties have to be a lot more informed, and the arbitrators have to be a lot more informed about the risks and the issues that arise with greater integration of technology. We've covered a lot of the basics, right? Don't use free use tools. That is never a good idea in terms of protecting your privacy. In fact, there is a very recent New York case about how someone had put in materials they had gotten from their lawyer into Claude and lost privilege over the sort of advice that Claude had provided to him. It's a very fact-specific situation, but there are all of these risks. Things that become all the more important: privacy, data privacy, cybersecurity, actually being aware of what's in the terms of use of a lot of these tools, being able to encrypt your emails. For a lot of neutrals, they use, and they're independent, they're not in big firms, for example, they use a basic Gmail. To what extent have you protected that so that parties can't, or so that bad actors can't access information, and you would therefore be compromising confidentiality? The second big area of that is also that I think confidentiality orders are going to get more complicated. In most cases, standard confidentiality doesn't really work. So as an institution, we actually do encourage parties to come up with confidentiality orders for that particular dispute to be able to cover what they feel they need. Right? A lot of these entities have different considerations. You might be listed. You might be a government or a state-owned enterprise or a state in and of itself. And then you have different disclosure requirements that a broad brush set of institutional rules would be incompatible with your own disclosure obligations. So that's going to become a lot more complicated. As an institution, what we've ended up doing since 2016, I believe, is that we make sure that the parties and the arbitrators discuss cybersecurity and data privacy in the first procedural hearing. What are the agreed upon minimums? What's going to become more important is that parties discuss what happens when someone is hacked. What are the consequences of that? Where does liability lie? What are the sort of issues that would arise? What are the sort of protocols that we then put in place to be able to protect all of this data? It's a conversation that we're trying to encourage between parties, the arbitrator. To some extent, the institution, as I mentioned at the start, just provides certain guardrails and allows the parties and the arbitrators to craft what's right for that particular case.
So I think an institution can guarantee you that there are certain safeguards that will be put to your data, your dispute, and your confidentiality, I feel. Moving on to, you keep coming to India and you have widely participated in Indian events. You were here for Delhi Arbitration Week, you're here now. What's the ICDR's perspective on the changes that are happening in India with respect to ADR, specifically arbitration?
I think India has a very large population of people that are very well educated on ADR. Knowledge and process knowledge is probably at an all-time high right now. And the pool of people who are interested in this just keeps growing and growing and growing. With that, I want to see a little bit more understanding of how the commercials work. Because at the end of the day, ADR is just a process by which we resolve disputes. And it has to go back to the fundamental substance of the law. So this is a question that some students asked me yesterday. I really want to be an arbitrator. How do I be an arbitrator? And my first position is always, how old are you? Because a decision maker's job is generally a more senior job. And I'm not saying you need to be 50 or 60 years old. You probably need about 10, 15 years in practice to get a good understanding of it, to be able to see patterns of human behavior, understand what's real, what's not real, and come to a judgment. All of this knowledge of process is great, wonderful, invaluable. Nobody will ever take it away from you. But the parties are looking for the commercial solution.
Yes.
Do you understand contract law?
Yeah.
Do you understand complex construction and complex energy? Do you understand the transition, India's policies towards green energy, and the regulations, the massive complex regulations that come into play? Do you understand intellectual property? If global trends are anything to go by, it's a matter of time before that becomes increasingly arbitrable, right? Do you understand that? These are all specific, substantive, as opposed to procedural areas of law that I would like to see more discussion on. It's also why we frame our programs in the way that we do in India. So we just had our conference in Delhi on Saturday, and there wasn't a single procedural panel. We started out with technology, we went into construction, we went into energy, we went into joint venture and shareholder disputes. We ended the day with life sciences. And of course, we had an excellent fireside chat with a current Delhi High Court judge and a very famous arbitrator to close off the session for us. But very little procedure, bringing everything back to the substance of the law. But what I've seen is really great sophistication by the courts, by the arbitrators, by the lawyers, by the academics, by the students. What we need to make sure that we push them to do is to resolve these disputes in as commercially grounded a way that's possible, so that arbitration continues to be well loved by both your state actors as well as your commercial actors.
Absolutely, I agree. And I think we need to push more education, we need to educate more on ADR, because India is still catching up with the rest of the world.
I don't agree with that. I don't agree with that. I'm sorry, I really don't. The conversations that I've had in India have shown me that people have a great understanding.
They do.
We can always improve. We can always be better. But I think to sort of say that India is catching up, I'm not quite sure that's accurate.
I'm saying that because we are massive in population wise, and the dispute docket that we have is massive. And when it's going to be exploded, we are going to need professionals. And right now, professionals are overburdened with ADR, because as businesses are realizing that arbitration and mediation is the way forward, they are opting for it. And they are finding it difficult to find professionals who are really good trained, because there are very few. And because of that, I'm saying we need to, because we went to as IIDRC's program, we do open houses. So we go to litigation, like courts, district courts, high courts, different tribunals, and there we interact with the counsels, the advocates over there. And when we talk to them about ADR, so they know that there is mediation, there is arbitration, but it's very limited that they know about this entire scene. So that's why I was saying that when this scene is going to be exploded, this, because I feel that in 5 to 10 years, the commercial matters, most of the commercial matters are going to be on arbitration and mediation, because the commercial courts over here are also not, doing that well that they're supposed to. So that's why we still need that education. We are catching that. We have judges, we have counsels who are representing foreign clients in London, in Dubai, in Singapore. So that's there. But there is still one of professionals who are just insulated from there. So we need to educate them, because when the
I think your
domestic,
point is a little bit different.
yeah,
I think your point is actually, and actually this is tracks with a lot of the advice that I've gotten here and the requests that I've gotten on this trip, which is maybe a lot of training is concentrated in parts of India.
yeah,
And therefore, the professionals that are well trained might be in particular locations within the country.
exactly.
And what needs to happen is that we spread that out a little bit so that it's pan India,
Yeah,
as opposed to concentrated within one or two cities. That is a point that I think a few people have now brought to my attention. We are trying really hard to make sure that our programming goes out pan India. So apart from being in Delhi and in Bombay, of course, we try and do some programs in Bangalore, in Chennai, in Ahmedabad, in cities and in places all over India. I know that the domestic Indian institutions are doing a great job with that.
Yeah.
I know Nani Palkiwala, I just met Payal, and I know that they're doing great work. You guys are clearly out there as well. So the domestic institutions really are leading the charge, to the extent that anyone wants to partner for knowledge across India. That's something that they can drop me a message about. But it's, you're right, that it maybe is a little bit concentrated at the moment, and there is potential for it to be spread out a little bit more.
Yeah.
But you will also see that that is a big country problem.
Yeah.
You have that in countries that are bigger than the size of Singapore, which is everywhere. It's a matter of time. But I think the Indian institutions are doing a really great job.
Yeah.
The Indian universities are doing a really fantastic job.
That's kind of.
There are also people, random people,
Yes.
who are trying to spread this education, sometimes in specialist sectors, sometimes just ADR. There are students who are doing it as well. So you've got a country that's really fired up about it.
Yeah.
I am very optimistic.
I've met a lot of heads of different institutions, and they are very keen on promoting AADR across the country. They are very keen on making aware people about ADR, making business aware about ADR. Thank you, Thara, for your time, for your valuable time with us. This was indeed a very valuable conversation that we had today. And with that, I would like to end this podcast and request you to watch, subscribe, and like this podcast. Thank you.
Thank you.